testimony. So I was relying on the verbal information, not the extrinsic information, to elicit the testimony. And that's all.
That is.
If Your Honor disagrees, then Your Honor disagrees. That's all I can
I do disagree, because you know what you're doing? You're trying to walk a fine line and a tightrope on this situation, but you know that electronically stored information needs to be turned over. So that is why you're saying, I'm going to rely on the testimony that you know has electronically stored information to it. You know it. And you decided in a deliberate attempt to not turn it over, that you would just elicit it on the stand outside of turning over the physical.
A shocking courtroom battle unfolds as a defense attorney finds herself under intense pressure after a judge discovers that crucial digital evidence was not disclosed before trial. In a case involving a family's tragic murder and a defendant accused of killing his own brother, the courtroom erupts when Judge Mark Lemieux questions why a screenshot hidden in the defense's possession was never handed over to prosecutors. As the judge breaks down the timeline and accuses the defense of attempting a trial by ambush, tensions reach a boiling point. But was this a deliberate strategy, or a misunderstanding of legal discovery rules? The answer would become one of the most dramatic moments of the entire trial.
The actual physical phone that documents the screenshot, that physical phone and what's located there, do you agree with me that's an electrically a stored document within her phone? Do you agree?
From the moment she took it, sure.
And from the moment that you knew about it, correct? It's an electronically stored document, right?
I don't know if that's within the context of the discovery.
I'm asking you a question, yes or no. The answer is either it is, or in your opinion, or it's not. So
in my opinion, it is electronically stored in her phone. Yes. Is it electronically stored as far as do I have access to her phone? I didn't have access to her phone.
Well, actually you did, because you actually got a screenshot of it, according to you, the day before, so you did have access to.
This is the moment where the courtroom tension begins to rise. The judge challenges the defense's explanation and suggests that the issue is not simply about a late discovery, but about failing to follow required evidence disclosure rules. This sets up the central conflict of the hearing.
Not only to her phone, but the fact that you received a screenshot of it. Am I correct?
I would disagree, Judge. I'm on the phone with Katie. She's giving me information in live time. This is less than 24 hours before she's set to testify. And she informs me of something for the first time, and in live time says, and by the way, here's a screenshot of it. So this is less than 24 hours before she's testifying. It's not clear that this is, my understanding is if I'm not going to actually use the physical item, I didn't think it would be necessarily fair. I have to say, I had a fleeting moment to really think about it. But I didn't think it would be fair to surprise the state with this document and say I'm going to use this tomorrow, or I plan to use this tomorrow. So I relied on what she verbally told me to elicit the testimony. I think those are two distinguishable things.
I don't think they are. I don't think they are at all. I actually think that you had 24 hours, according to you, if you're actually assuming your information is correct, that you had a significant amount of time, that you had a screenshot of information that you knew you were going to elicit the next day, and that you did not turn it over. You didn't turn it over on Sunday. You didn't turn it over on Monday morning at 8 o'clock when we're all here a half hour before we started. You didn't turn it over at the first break at 9:30 or 10 o'clock.
This is one of the strongest moments in the hearing. The judge's detailed timeline makes the argument feel personal and direct. Instead of speaking generally, he shows exactly when the defense could have acted, creating a powerful courtroom confrontation.
Problem with what you're saying. So I'm going to give you another opportunity as you're talking to the court. When you look at this information, is it or is it not electronically stored information?
Judge, frankly, I don't know. I don't think it's clear. Again, my interpretation of the discovery obligations are that if I am using something at trial a physical, extrinsic document or piece of evidence, then I have to turn it over. And there were many things that were turned over months ahead of time because I had them months ahead of time. All I can say is I had this item the day before she was going to testify, and if I had not had the item, if it wasn't sent to me, and all I had was her verbal information, I would have just elicited the testimony.
Opportunity to object, it happened so fast. So the reality is simply this. I hear you as it relates to this issue. I 1,000% disagree. This is not what the Supreme Court at any point in time contemplated when it considered tier. This is not what it did. There's no way. And when I look at State v.
This is the emotional peak of the argument. The phrase, trial by ambush, becomes the defining moment because the judge clearly believes the defense strategy could unfairly surprise the prosecution. His tone shows frustration and authority.
Of these locations from February 2019. The electronic location that she looked at from 2019, is that stored in her phone as of today?
Not that I know of. She's just relaying what she saw back in February of 2019.
That's not what I'm asking you. I'm asking you whether, obviously, you're having a conversation with her as it relates to the other text message. And there, she's like, I have a screenshot. I can't sit here and not think that somebody who's preparing a witness in a case like this wouldn't ask a question. Do you have anything in your phone that says that the location comes back to Corey's house in February 2019? Are you saying that you never tried to see if that information's electronically stored in her phone?
That's exactly what I'm saying. I didn't ask that question because she just mentioned that when back in 2019 she looked at it and saw that it said that it was at Corey's house. And because I was under the impression that they obviously had the iPad at some point but never seized it or searched it the same way that they did to Sophia's phone. And just so that the record is clear, I also want to note the text message that she sent to Jennifer, the state did a cell phone extraction. They have her cell phone extraction. When I refreshed her recollection, I wasn't using...
I know you weren't. That's what makes it even worse. You decided to use an electronic document that you know was not 100% accurate because the document that was 100% accurate to refresh her recollection would have been what you had in your possession, which was the screenshot, which included underneath the word read, which is what you supplied in your exhibit. So you had something, again, in your possession that you consciously decided not to turn over. And then, when you're deciding to refresh somebody's recollection, you decided to use a document that, okay, this is in discovery, so I'll use this, but then I'll ask questions and get a verbal response as to the other information that's electronically stored in the phone. That's not appropriate. It's not in any way, shape, or form.
Judge Lemieux expressed his frustration.
This scene expands the controversy beyond one screenshot. The judge suggests there was a pattern of handling electronic evidence improperly. It shows the court's concern about transparency and fairness during the trial.
Either text or phone call. Do those exist?
I don't know, Judge. I'm being in candor to everyone. I'm just relaying the context of the conversation and what was told to me. That's all. The court is clearly being accusatory toward the defense. The court is using words such as conscientious or conscious and deliberate and intentional.
I'm using it because it's true. I'm using it because it's true, Ms. Maslone. So don't say that I'm using these words for any other reason because you did this. I didn't do it. I've given you the opportunity to ask questions and do whatever you need. And the reality is, you can roll your eyes for the record as you just did, but the reality is simply this.
This is one of the most intense exchanges between the judge and attorney. The judge personally rejects the accusation that he is being unfair and explains that his criticism is based on the defense's own actions regarding evidence disclosure.
Okay, so hold on.
It was just failure to investigate and seize and search the iPad.
No, that's actually not, because the first thing that you say
is that people were in the home.
I'm sorry, I think I was talking. The first thing that you say deals with the fact that they are in the home. They are in the home taking stuff out. It demonstrates that Corey was taking items from the house after the homicide, which lends to further credence to the defense's earlier point.
Yes, exactly.
The reality is this. It goes to his behavior. It doesn't go to the fact of something that happens in 2020. A contamination of the scene in 2020. It's not like we have evidence here of Corey's DNA in the kitchen so that we have some contamination issue. What this evidence is being used for is to show that Corey is actually in the house just taking items out, and it goes to his behavior. That's what I find. It goes to his behavior, which is exactly what, in my January 27th order of a 42-page opinion, which I said specifically that area of testimony was not going to be allowed.
Judge Lemieux.
This moment highlights the judge's role as a gatekeeper. He makes clear that the jury must rely on evidence presented in court, not speculation or assumptions about someone's actions.
Forensic evidence, eyewitness testimony, or other direct proof connecting the alleged third party to the crime scene, the court found the theory of third-party guilt to be pure conjecture, constitutionally permissible as a concept, but legally insufficient as presented. The judge ultimately clarified that the issue before the court was not a Sixth Amendment question at all, but rather a straightforward matter of compliance with the rules governing electronically stored information. On February 13, 2026, Paul Canero was found guilty on 15 counts, including 4 counts of first-degree murder, aggravated arson, possession of a weapon for an unlawful purpose, and misapplication of entrusted property. On May 12, 2026, a judge is scheduled to sentence Paul Canero, who faces a potential term of life without parole. This case underscores the critical tension between zealous advocacy and the mandatory discovery obligations that underpin a fair trial. When a defense introduces late-stage digital evidence in support of a theory of third-party guilt, it challenges the structural integrity of the adversarial process itself. Judge Lemieux's firm intervention highlighted what the court perceived as a deliberate withholding of evidence that counsel had long been aware of, held in reserve until the trial reached its most consequential stage. By rebuking such trial-by-ambush tactics and enforcing strict adherence to
The ending connects the courtroom conflict back to the final verdict. The judge's strict handling of evidence becomes a major theme, protecting the integrity of the trial while ensuring both sides follow the same rules.